Welcome everyone to a Condominium Management Group's webinar. So today's January webinar focus is the Condominium Authority Tribunal jurisdiction and expansion this month. This is widely known as CAT. Our webinar today will be slightly extended to a full hour. We have a lot of information to cover, and again, thank you everyone for joining. Let me introduce today's guests. So we have Nancy Houle and Graham McPherson. So Nancy is a founding partner at Davidson Houle Allen. She has practiced exclusively in the area of condominium and joint property ownership law since being called to the bar in 2002.
20 years, Shelley, 20 years.
20 years. My gosh, where has it gone, Nance?
Thank you for having me, Shelley.
And also, I would be remiss if I didn't mention that Nancy is also our current president of CCI-EO, so Canadian Condo Institute. Welcome, Nancy. We also have Graham McPherson. Welcome, Graham. Graham is an associate lawyer with Gowlings. And of course, you might recognize Graham because Graham is part of the condo advisor team and the webinars. The duo, well, I wouldn't say the duo.
I'm one of the condo twins, as Rod calls us. Arguably, now that I'm nobody's here to correct me on it, I'd say the more handsome and funny condo twin. Hopefully, David doesn't watch this on YouTube.
I won't dispute it.
Thank you.
I agree. And welcome to both of you this afternoon. And thank you again for joining the discussion. So again, the discussion today surrounds cats. Now, I believe both of you have cats. So you never know.
I actually took my fluffy bed down so that she wouldn't walk in with her tail in front of my face today, as has happened on past webinars. So keep our fingers crossed. Graham, I loved yours.
Yeah, mine's passed out right now.
It's like, disturb me. Please don't disturb me.
Yeah, exactly.
So let me go ahead by sharing my screen here, and we will
actually, you know what, Shelley, while you're just getting your screen ready, since today is Bell Let's Talk Mental Health Day, we can put a pitch in for our real live cats, not the cat that we're going to talk about, but real live cats. I, for one, have found that having a fluffy critter beside me at all times has quite enhanced my ability to work from home. I'm not sure about you, Graham, but I think it helps.
Yeah, absolutely. I mean, I think the pros definitely outweigh the cons. The cons being that there's a lot of stuff back there you can see that she enjoys knocking over. But it's definitely a help. And when working from home, especially if you're working from home alone, it can get kind of lonely and isolating. So having a little critter companion can do a lot of good.
Yeah, absolutely. And a lot has to be said for mental health in this industry. And I believe it's really, however the balance is, whether it be your cat or otherwise, we really have to bring that balance and sanity into our lives these days.
Agreed.
So we have, I believe you can see my screen share now. Okay, so again, welcome. And so I had mentioned too that Nancy is, and so am I, we're both directors. Nancy is the president of CCI-EO. And if you'd like further information, please visit the website for CCI-EO regarding membership and education opportunities too.
And Shelley's the membership chair and on the education committee, so you can always reach out to her directly. She has all the answers.
Thanks, Nance. So I'm going to just jump right into it by actually, we have the poll that we might want to launch right now, and this is about if you have ever submitted a case to the tribunal, or have you ever been involved in a case with the tribunal? So if you'd like to go ahead and vote, you should see the poll up on the screen, and the results are coming in now. Thank you everyone for participating. We have quite a few, it looks like, that have never had a case that's been submitted to the tribunal or involved in the CAT. So we'll end the poll and share the results, and you can see the majority have not. So that definitely gives us a good indication of our audience today.
This is terrific, actually, to let us know where we should focus our comments. Thanks for that, Shelley.
Absolutely. And so with that being said, I will hand it over to you, Graham, to proceed with about the CAT process.
All right. So thank you very much, Shelley. And thank you everybody for being here today. The Condominium Authority Tribunal, or the CAT, is an administrative tribunal that handles certain types of disputes. And we're going to get into what its jurisdiction and what those disputes are. But because it's a tribunal, how the law in Ontario at least works is that if you are presented with a case or a problem that would normally go to court, but there is a tribunal that has the jurisdiction to hear that case, you have to go to the tribunal. And so it's going to become, as we'll see as we go further in this presentation, the CAT's jurisdiction is continuing to expand. And while 95% of our respondents there indicated they had never been involved in a CAT case, I suspect that number is probably going to change in the future based on the expanding jurisdiction. So what we're going to do is go through that jurisdiction, and I'm going to start, before getting there, on just kind of what the CAT is and what its process is like and what it's like to be involved in it. So the CAT is an entirely online tribunal. The entire process from beginning to end takes place 100% on the internet or through the phone. And that includes even filing your case with the CAT, which is done on the CAT's website. And to file a case, you have to fill out, basically, it's a very easy to fill out form on the website, wherein you upload all of the relevant documents to your case and you put in a quick little blurb about what the case is about. Once that's occurred, you have to make sure that the other side, so if you are an owner and you're submitting a CAT case against your condo corporation, or if you're a condo corporation and you're submitting a CAT case against an owner, you need to make sure that the other side gets notified. And so the most surefire and safe way to do that is, once you get the notice form that the tribunal will create, the best thing you can do is print it out and make sure it is actually delivered to the person it needs to go to. So if it's the condominium, it can be sent to the address for mailing that's on the CAO's registry, or if it's the owner, you need to make sure it's served to them personally. Now, if you have an email address, because again, it is an all online tribunal, if you have an email address for the person or entity you're trying to add to this CAT dispute, the CAT will automatically email that person with the notice. And if they respond, great, they're in, then you can keep moving. If they don't respond, you do need to make sure that you actually get them served. There's nothing more annoying than putting a whole bunch of effort into something and then having it kind of fall apart at the end because it turns out you weren't able to properly serve them. Now, putting aside all that administrative stuff, once both sides have the dispute and know what's going on, the first stage of the CAT is stage 1, negotiation. And that's where it's sort of, for those who remember MSN instant chat, it's kind of like that, whereby it's a very informal process where both sides can message each other and see if they can reach an agreement by themselves. And it's quite informal in that there's no real supervision of it. It's just an opportunity for both sides to be in one place with all of the relevant documents and information in one setting where they can hopefully resolve the matter. If they're unable to do so in the negotiation stage, the CAT process moves on to stage 2, which is mediation. And in the mediation stage, for those who have been involved in an in-person mediation, it's very similar in that the CAT will appoint an impartial mediator who will work with the parties between them to see if they can help negotiate a settlement. And so this mediation happens by way of text communication online. So the mediator will post something and maybe ask both sides to comment on it, and usually give a deadline to do so, and both sides will have to do so. And in that way, there's a lot of back and forth. The mediator can talk to one side alone. The mediator can talk to both of you at once. You can also set up phone calls if you think that's going to be more effective. And in that process, which usually lasts about 2 to 4 weeks, the mediator will see if a settlement can get reached. If it's looking like that's not going to be possible, if you can't settle all of the issues, then the mediation's focus will then shift to, okay, if we're going to have to argue about this, what are the types of issues we're going to be arguing about? How long do we think it's going to take? What is the evidence going to look like? All that type of stuff. And as you can see, as the process goes on, it kind of starts to look more and more almost like a court proceeding. And when you get to the third stage, the tribunal decision, it is very much like that. In this stage, the CAT will appoint an adjudicator who's going to hear both sides' stories of the dispute. And in so doing, it proceeds just like a court case, in that both sides will have to present their evidence. This can be done either by way of Zoom or telephone, or even by way of written statements. And then the other side is able to ask questions of the witnesses, and it really does run like a trial, in that the evidence is exchanged, you're able to ask questions to the other side in front of the adjudicator, and then at the end, both sides will make a legal or argument phase to pitch why they should be successful. After that, the CAT's adjudicator will mull over the evidence that they've heard and render a decision at some point, which will resolve the matter one way or the other. And if we go to the next slide, I just want to point out some kind of helpful tips. And by the way, that diagram you saw there, I'm not nearly as artistic as you may think. That comes from the CAO's website, where there's actually a whole wealth of very useful information. If you do find yourself at the CAT, there's some very good information that you can find there. Now, as I mentioned, it's an online tribunal, and a lot of the communication happens by way of written messages. And so this means it's quite email intensive. Anytime there's any update to your file, you get an email about it. So you need to be ready to, emotionally ready to have your inbox kind of attacked. And you also need to be prepared to promptly and professionally reply to these things and be responsive, because the mediator and the adjudicator especially are going to expect that if you are at the CAT, it's an administrative tribunal, there are real stakes. And so you need to be prepared to answer on time and be awake and alert to it. And if you fail to meet some of these deadlines, it can actually really impact your possibility of success. In fact, a lot of CAT cases are ultimately decided because one party just doesn't answer. Now, again, there's a little restatement here of the phases, and I think we did get a question that well, we got a couple of questions here. And now, Shelley, I'll defer to you on this as our moderator. Do you want to handle questions as they come in, or do you want to do them at the end?
I think some of them are quite relative to what you're speaking to now. Like, so one of the questions was, is the first stage moderated? So the first stage would be negotiation. Is it moderated, or is there a record of the negotiation exchange?
There's a record of it in the sense that, I mean, you can always copy and paste anything that gets written down and keep it for yourself. But in the same, and this holds true of the mediation stage as well. But in any sort of adjudicative process like this, when both sides are kind of negotiating and offering and trying to settle, those types of discussions are things that can't really get used in the adjudication phase. They're without prejudice. And so you can't, for example, if Shelley were to sue me because I stepped on her toe, and I said, Shelley, you know what, I agree, I did wrong there. If we can make this all go away, I'd probably be prepared to maybe settle with you by paying you $1,000. Shelley can't go tell the court that he admitted it, he was prepared to pay me. So those types of negotiations and settlement discussions are kept confidential. And with respect to the question about, is the negotiation phase moderated? To my knowledge, no. Nobody from the CAT certainly gets involved, and I would be very, very shocked to find if someone was behind the curtain actually reading it all, because that would be a lot of homework.
Yeah, and I'll jump in for 30 seconds here. One thing that I do see frequently with self-represented owners on the other side of a CAT proceeding with respect to this dialogue is they will download, copy and paste it, as you said, Graham. And then sometimes what they'll try and do is they'll save it as a separate document and upload it during the tribunal stage as evidence. And so if you're nervous that somebody is doing that, of course, you can download it for your own information and for your own knowledge about where someone's case is going. But if somebody else, if you're nervous that somebody else is going to try and use it as evidence against you, you can ask the tribunal member at the outset to remind the parties of how the information gained during negotiation mediation is to be used, because we've definitely seen it used that way.
Great, thank you, Nancy. Graham, one other question, and Is there any process if somebody doesn't use email or is not online? It is an online strictly tribunal process, isn't that correct?
It is, and I think the most that they could do for you is try and make it so that that as much as is possible takes place telephonically. But I mean, to upload your documents, it needs to be online. And the entire interface of the tribunal is online. I mean, it's always possible that there are people with absolutely no internet access and zero internet literacy. And it is an administrative tribunal, and I'm sure it would do what it could to try and accommodate. But to a certain extent, it is also going to be cognizant of the fact that at this day and age, especially after the pandemic, I mean, it's not unreasonable to ask people to have some sort of computer or telephonic access.
All right, thank you.
So for our next slide, I think is where we get into the jurisdiction. Exactly, yes. So you may be wondering at this point, so when would I end up at the CAT? What sort of disputes would take me there versus take me to court? And the CAT's jurisdiction has expanded a lot over the last 2 years. Initially, for its beginning and its inception, the CAT was only here with respect to records requests. When an owner would submit a formal request and they would, and the corporation, for whatever reason, maybe it didn't have, or maybe the records being requested weren't something that it needed to keep or needed to share. When there were disputes about that type of thing, the CAT would hear these disputes, and that's how it was for quite a long time. Now, in late 2020, the CAT's jurisdiction expanded, and it expanded to include disputes regarding pets, parking, storage, and also chargebacks about those things. And then in January of this year, so very, very recently, the CAT's jurisdiction expanded again. And now we also are hearing disputes, well, the CAT is also hearing disputes about nuisance. So that's noise, smell, smoke, vapor, light, vibration, or any other nuisances that are described in a corporation's governing documents. And so if we go to the next slide, I just want to illustrate that, you may be thinking that, okay, well, pets, parking, and storage, nuisance, those are all pretty discrete, Graham. I don't think that's going to take me to the CAT all that often. And I just want to maybe send out a little warning that pets, parking, and storage and nuisance may sound a little reductive, but it might go a lot further than you think. For example, when it comes to pets, the CAT has the jurisdiction to actually evict animals, including service animals, from the building. The CAT also has demonstrated that it has the ability to actually determine whether amendments to a declaration were valid. There was one case where there was an argument about parking and guest parking, and the condo corporation was relying on an amendment to its declaration that it made, and the CAT ultimately found that, looking at the process by which a declaration has to be amended, this corporation didn't do that properly. And so not only was the corporation unsuccessful, but it now has a public order online indicating that its declaration wasn't amended properly. And there's other cases involving pets where the corporation, similar to the case I just talked about, was trying to rely on a rule to enforce a pet rule. And the condominium found that, or the CAT found that this rule, again, it wasn't set up according to how the Condominium Act tells us that rules have to be, and it's really more like a policy, and so you can't be enforcing it in this way. And so the moral of this story, I don't want to get into the details of the cases or do case studies because I don't think we've got the time or the inclination to do that, but I do just want to flag that as the jurisdiction continues to expand, it may very well include things that weren't kind of what we initially thought when we just saw those little words, pets, parking, and storage, and now nuisance. I was hoping today that I would be able to show you a cool nuisance case that the CAT had, but unfortunately the first and only nuisance case that the CAT has published was a nuisance case. In that it was an owner who was very concerned about the way in which certain officers of the corporation were appointed, and they thought that that was a quote unquote nuisance, to which the CAT said, no, it's not, and it punted the case. So unfortunately, I don't have anything new to tell you about how the CAT is approaching its new jurisdiction yet, but I'm sure it's coming. And there's one more thing I want to say before I get to the last point, and I just want to note that I think, especially in light of the fact that 95% of our respondents said no, they've never really been involved in the CAT. I think something we're going to all want to remind ourselves too is that when it comes to your status certificates, the CAT is an administrative tribunal, and as this jurisdiction continues to expand, we're going to see more CAT cases. And on status certificates, of course, we all know that if we're involved in a court or an arbitration process, we need to include that on there. But it also asks for tribunal cases that the corporation is involved in too. So that's going to be something to keep in mind as these cases may become more prevalent. Now, one of the questions I'm sure everybody is wondering about, especially if it looks like this is going to become more popular, is what happens with respect to legal costs? And I think Nancy's going to take the wheels from here. Nancy, do you want to do that, or do you want to do our poll first to segue into it?
Maybe we'll do the poll, because I'm also seeing that we have a question in the Q&A saying how much involvement a corporation can expect to be part of if a case, for example, noise is an issue between two owners. That's a great question, and there's zero black and white answer I can give you because it's very factually dependent, but we will try and tackle the issues that you'll see in a nuisance case, for example, noise, as we go through some of the various items later on. So let's do our poll, and then we'll get into some of the legal costs and the expanding jurisdiction.
All right, so the poll in regards to nuisance complaints. Let's see, have you dealt with a nuisance? Oh, let me launch this before I start reading it. There we go. A not compliant complaint.
Yeah, and not a cat one, right, Shelley? It doesn't have to be the cat, just nuisance.
No, exactly. Any
Have you ever dealt with smoking,
issues,
noise, issues like that?
Light vibration, light pollution, all sorts of other things.
So not something that's been brought to the CAT, but just in general, any complaint that would be considered a nuisance. So we'll end the poll, and it looks like
those numbers look very different.
Yeah, exactly. Quite a few in attendance have dealt with nuisance complaints in condos, whether it's smoking, noise. Yeah, stop sharing. There we go.
So yeah, we had 95% of our attendees saying, I've never been to the CAT, which was great. And that makes sense. For, as Graham was saying, we started off with records, then we moved into people, pets, and parking a little bit more. But now the jurisdiction has expanded dramatically, in our view, such that we now see numbers of 75% of those in attendance here have dealt with exactly the type of issues that are now going to be within the jurisdiction of the CAT. So that's a big change, and it's a big change that's going to result in some big changes in how you make decisions. What are the issues you need to be considering going forward when you get hit with a CAT case? Because I do believe that it's probably only inevitable for, I'd say, at least 75% of those we've heard of here today to have CAT cases coming down the pipe. As Graham said, historically, records cases, very low costs. Yeah, your managers could take care of it. The board could take care of it. Once we started getting into the parking cases, the pets cases, we are seeing things that are starting to expand into the jurisdiction of declaration interpretation, amendments to declaration, amendments to rules. We still had a lot of representation, self-representation by boards and managers, but we started to see more legal involvement there. And with the more increased expansion here that we're seeing now, we think that with the complexity, the type of cases that we're going to see, we really need to start thinking about a key topic that we're going to start to narrow in on a bit over the next few minutes. Who should be representing your condo at the CAT? Now, let's back it up a bit then. Legal costs. So when you're thinking about who's going to represent the condo at the CAT, one of the things you need to be thinking about are your legal costs, right? So it's easy to say, well, let's just get legal involved and we don't have to worry about it anymore. Or it's also easy to say, well, we don't want to incur legal fees, so let's just have the board of directors do it or our manager do it. It's not always as simple as that. So what are we talking about? What are we seeing for legal costs? With records cases, historically, we saw practically no legal costs being awarded because, again, it really didn't need to get into that extent of legal costs being awarded. Historically, there's been a principle in the law that the innocent owner should not have to pay for the costs incurred by the corporation for one owner who is vexatious or who commences proceedings without merit. On the other side, the corporation should have to absorb costs if they treat one owner or a group of owners unfairly. So historically, the principle has been that whatever party was in the wrong, so to speak, would indemnify the other. And again, that's a primary principle in condominium law, to protect the innocent owners when only one owner is the cause of the problem. And in order to achieve that, historically, there have been indemnification provisions in the corporation's declarations, bylaws, or rules, and the courts would enforce those historically. With the introduction of the CAT in 2017, a few years ago, we didn't know what that was going to look like. How was that going to change? In the first few years, again, we didn't see much of it. Within the past year and a half, 2 years, since the pets and parking issues have come to light, we are starting to see how the CAT is treating legal costs. We're essentially seeing the CAT breaking costs into two separate types of costs, and you'll see them broken down here. We call them pre-CAT costs and recovery during the CAT hearing. So CAT costs, pre-CAT costs and CAT costs. The pre-CAT costs are the costs that you've incurred to try and get to the stage of getting compliance and getting to the CAT. So the legal fees on the letters that you've sent, maybe the management fees if you've had to incur extra management fees, maybe the contractor's fees if you had to come in and get some damage cleanup. So those would be your pre-CAT costs, and legal costs are included in there. Your CAT costs are then the costs that you incur primarily just from legal, perhaps from management if they have to put extra time in as well, during the CAT proceeding. So once the proceeding is filed, leading up to and including the tribunal setting if you have to get there. What we are seeing is that the CAT is becoming more and more inclined to order costs, either pre-CAT costs or CAT costs. It took a while to get there. We didn't see much in the way of costs being ordered for probably a good year or so. But within the past 6 months, we've seen a couple of cases come out where the CAT has been quite interested in awarding pre-CAT costs, particularly when the corporation crossed its T's and dotted its I's leading up to the CAT hearing. Shelley's going to talk later on about how to avoid the CAT, and creating this record and doing everything right is part of that process. And we are seeing the CAT now a little bit more interested in awarding costs as long as you've crossed your T's, dotted your I's, where there's an unreasonable person on the other side, resulting in those pre-CAT costs. Graham, I saw you unmuted yourself. Did you want to jump in before I get to the CAT costs?
I was just going to say just a very quick answer to a question I think probably directed at me when I was talking about the expanded jurisdiction. Very quick one. Why would the CAT want to get involved in nuisance complaints? I'm sure it's not an issue of want so much, but as anyone who has been involved in the court system before likely knows, the wheels of justice turn slowly. The courts are quite busy. And so what the purpose of these administrative tribunals like the CAT are is that whatever disputes can be taken away from the court so it can focus on other things, and then given to specialized adjudicators who deal with this one type of thing or this few types of thing and that only. It kind of helps streamline how quickly everything can move.
Great, thanks, Graham. So I'll go into, I think, the third question I see on here, qualified as pre-CAT and legal costs and CAT process legal costs. I think I'm sort of answering that. So hopefully as I go through this, that'll help answer that question. So the pre-CAT legal costs really are everything leading up to the CAT, up until you start that CAT process is started. The CAT process costs are then the costs incurred to respond to the CAT process or to initiate the CAT process. And we'll talk about that in a few minutes as to why we might see some changes there as well. And so we are seeing, and this goes to the first question by Karen, will the CAT decisions now set precedents for cost recovery? They're low and the costs can be high. Completely agree, Karen. What we are hoping is that as the increased jurisdiction moves forward, as we are seeing complexity of cases increased, we will see better CAT decisions on CAT costs. So what are we seeing in the past 6 months on CAT costs? We are seeing the CAT using what is called the exemplary provision or exceptional provision. There's a rule in the CAT rules that says if there are exceptional circumstances, the CAT can award legal costs for the proceeding itself. And so we are seeing a couple of cases, one recently where there was $17,000 in costs. And I see I just froze there, folks. So I'm just going to stop my video for a second and I'll restart it in a moment. $17,000 in CAT costs were awarded to the condominium corporation because the corporation did everything they possibly could the right way, and still they weren't able to get compliance. So there were exceptional circumstances there. Very recently, the Government of Ontario, in conjunction with the CAO, has opened up for comments about legal costs, about what can we do, or what should the CAO and the Government of Ontario do with respect to legal costs. So legal teams across the industry, including CCI, have made submissions to the government to try and protect condominium corporations from these costs, to increase the authority and increase the awareness that these costs should not be borne by the innocent owners. We've also asked that a particular provision in the Condominium Act, which deals with indemnification provisions, be enacted, because working hand in hand with the CAT rules, this indemnification provision in the Condo Act could work together to allow the CAT to give even more legal costs as their jurisdiction increase. So we're keeping our fingers crossed that we're going to see better legal cost awards as we move forward. And again, as we see these cases becoming more complex, this is going to be very important. It's going to be very important because the next question is, who should represent your condo at the CAT? We have 3 pools of individuals we can choose from for representation at the CAT. Essentially, your members of the board of directors, your manager or representative from the management company, and your legal counsel, whether it be a lawyer, a paralegal, or a student. You heard from Graham earlier on. There is a ton of work involved in a CAT process. It's email intensive. You have to understand that system. You have to get familiar with the system before you even start being able to navigate it. It takes, I'd say, a couple of weeks to really get comfortable with the system before you're able to navigate it. In some cases, you might even end up setting up a separate email address for a CAT case because, as Graham said, your inbox is going to be inundated. It's not unusual to see 12 to 20 emails in a day, right? That's not unusual for one case. So again, it's very, very intensive. So if it's your board of directors handling this as, volunteer members of the boards, you have to think, is that really something they want to do? But I'm giving you a little bit of a highlight of some of the issues to consider. So it takes a lot of work. There's a lot of emails. And so it's a really tough decision to determine who is best suited to be handling these types of cases. So let's talk about who gets the authority and where they get the authority from to handle these cases. So the board members, they get their authority, obviously, just by virtue of the fact that they are board members, right? They're the representative of the corporation. Your property manager representative or an agent of the management company, they get their authority from a specific rule in the CAT rules that allows for an exemption from the standard requirement for legal training. Typically, you have to be a trained lawyer under the Law Society of Ontario or a paralegal or a student in order to appear in tribunal settings on behalf of a corporation. But there's a rule in the CAT proceedings that gives an exemption for managers. And then, of course, the third group is the lawyer, paralegal, student, et cetera, and they get their authority from the LSO. So that leads us right into, how do you choose who you're going to have do this? And I'm going to, I think, just set out 5 or 6 key points to think about. And then we'll open up, I think, Shelley, to that general dialogue to have about how we make that decision. And I guess maybe I'll start off with saying, we are a law firm of, 12, anywhere between 10 and 12 lawyers at any given time. At any given time, 4 of those lawyers do not want to litigate. They have no interest in going to court. So, if I've got a quarter of the lawyers in my firm who don't want to litigate and 3/4 who love it, we can't expect board members and managers to all want to go to litigation either, right? So the person who decides or who ends up being chosen to do this, they have to want to do this, particularly if you're a volunteer board member. The person has to have a certain level of training in order to do this, whether it's technological training, whether it's legal training, depending on the complexity of the issue, et cetera. So some form of training. They have to feel like they have to do it not because it's part of their job or they feel they should do it. And this is, I think, something Shelley's going to speak about more about. Some of the individuals, whether it's the volunteer board members or the manager, feel like, well, because I'm in this position, I really have to do it. It's not part of anybody's job until or unless you're retained to do it, or until or unless you make a conscious decision that this is something you should be doing. Another thing to think about, is there a conflict? For example, if you're a board member and you're the one who provided had the discussion with the individual owner about the nuisance, about the pet, or if you provided records to someone in a records case, or if you're a manager and you're the one that was engaged in trying to negotiate a situation between 2 opposing owners, are you going to be in a conflict giving evidence? Are you going to be in a conflict in being able to be an independent representative or agent for your condominium corporation? So these are the key things I think we need to be thinking about in determining who is the best candidate to represent the condo. And then, of course, obviously, taking costs into mind. Just before we turn it over to you, I think, Shelley, we have a question here. We just add to our insurance protection for legal cost fees. Is these pre-cat costs will cover by our insurance? The pre-cat costs likely won't be something covered by your insurance. The actual cat hearing legal fees might, but your insurance company may want to be the one appointing the lawyer in the same way as if they're the one that's handling your negligence claim. So it's something you'd have to talk to your individual broker on a case-by-case basis and see whether or not they'd be prepared to cover the cat proceeding costs. But again, you then may be at the subject to them taking over the case and deciding who they want to represent the corporation in that case. Shelley, did I cover all the key points before we open it up to the discussion?
Absolutely, I believe you did. And I'm actually going to stop sharing my screen for a second, Nance, so that if we're opening this discussion for a few minutes, our viewers could see everybody on the screen. But I think you really hit on a few very important points that when it comes to CAT, it's not an automatic of who deals with the situation, because the claims now and the cases, because of the expansion, especially, I see that it's not just records requests. Records requests, it could be very complicated, but the manager in many cases were handling that, and because they get the official mandated document that comes in for the records requests, they run it by the board of directors, they respond. There's the process for that. Now with the expansion, and feel free to jump in, Graham and Nancy, but with the expansion, I just think that it's moving into a more complex issues.
And I think one thing I forgot to mention is jumping off of some of the comments from Graham. When they were talking about the pets cases earlier, Graham was saying, we're seeing a lot, you think pets, but we're talking about service animals. I think that we're going to start seeing a big overlap between the Human Rights Tribunal and the CAT. And it's going to be very, very tricky to navigate. Is this something I should be asking to be stayed at the CAT and we go to the Human Rights Tribunal, or is it more appropriately dealt with at the CAT because now they say they want to deal with service animals? Or what if the owner already has a human rights proceeding and they bring a CAT process? And so I think it can very quickly, and without even realizing it, become more complicated than you think it's going to be at the outset. And so absolutely, I think we're going to see the types of cases, the number of cases skyrocketing, and the complexity being far beyond what we thought we would originally see.
Yeah, just what may start with what seems like a very simple dispute about you can't be using the guest parking spot like this can turn into, my God, did we actually vote on that bylaw correctly? So these are things that if you kind of get into it thinking it's going to be one thing, as it continues to expand, like Nancy said, human rights or condominium governance. I mean, what we know is that the CAT's expanded jurisdiction goes beyond the kind of discrete words that were given for it.
Absolutely. I'm just looking at our timing, and maybe what I'll do is just jump right back into our presentation and ways to avoid CAT. So again, if we could avoid CAT on the forefront, and that really helps a whole lot rather than getting into the process. And as property managers, condominium managers, excuse me, we have to find a means for sharing that information to ownership. So whether it's a portal, a shared website, monthly newsletters, open office hours, so that if residents or owners would like to actually see a hard copy of the declaration, for example, or the insurance certificate, that they could drop by the office and those documents are readily available for them. Have copies for them so that they could review the redacted minutes. Important to keep those redacted minutes handy. I believe that in providing and being as open as possible to those requests will help to avoid claims at CAT. And I believe that in many cases that if any managers have gone to CAT, we could and directors, we could say that how much of this could have been avoided in retrospect. So in some cases, we could have been a little bit maybe proactive in providing the information. So again, there are the mandated forms, but if there are core records, provide the core records. Now, again, the expansion, we've expanded quite a bit from just records now, but just speaking to records, that just provide them, and sometimes that's all that the that homeowner would like is the core records. So I just wanted to mention as well as we usually send out the notice of future funding. In many cases, homeowners are asking for the whole of reserve fund, the detail, the meat of it all. PDF it, send it out to everybody. It's a core document. You could send that out to all homeowners whenever you send out the notice of future funding. It adds to the transparency of the documents that are being shared with the ownership. So you could, the one thing that is provided to homeowners after the first quarter and the third quarter is the periodic information certificate. That allows more information as well as to the standing of the financial standing in the corporation, and sometimes a little cover letter with that to help decipher the information that's being shared. That definitely helps as well. So open meetings for the ownerships. So engage the ownerships, the owners with questions that have questions. So meet with the owners who have the questions and provide those answers. Provide maybe an FAQ in a newsletter. Have the regular frequent town hall meetings in addition to your AGMs. And before the pandemic, it was coffee with the board or cocktails with the board, maybe. Is to schedule something like that, just so that if owners, it doesn't brew to an extent where owners feel like the only way that they're going to be heard is to escalate this. It would be helpful to be proactive on the front end. So, the best advice I would say is to discuss it as a team, and with your board, the manager, and legal. So rather than bringing legal in on the issue or the claim when you're in the CAT process, is bring legal in to consult in advance. So maybe a 15-20 minute consultation to say, okay, look at all of our options. Which way shall we go? Who's going to represent us? Who has the time, the knowledge of the platform to represent us in this claim or this CAT case? So it would be good to lean on to your professionals to see what are all your options, as well as be proactive, maintain that professional and self-control whenever you're communicating with a homeowner about a complaint. If it goes a far way as far as showing compassion, empathy, and understanding the other side's concerns. In many cases, we'll go right ahead, Nance.
I was gonna say, I'm gonna share, because I think this is a really good time for me to just share some of the cases that we're seeing. There are a couple of cases, I think 2, and Graham, you can correct me if I've missed one, but I think 2 that we've seen within the past 4 months where the judges have hammered people for not trying to de-escalate. The message has been, this should not be here. Should not be at the CAT, should not be in the courts. You guys have a job, whether it's manager, board, or legal counsel in some cases, to seek to de-escalate matters. And so I think your points here, Shelley, about objectivity, de-escalation are really important. Is there another way we can try and handle this? Yes, you know what, maybe we want to dig in our heels here, but is there a practical way that we can de-escalate this and try and each of us walk away maybe a little bit unhappy, which means we've probably found a positive resolution.
I think that actually speaks to one of the questions in the Q&A about, is the CAT process adversarial by definition with a winner and a loser? Is it not a win-win? And I mean, it is an adversarial process like our justice system is, but like Nancy says, I mean, most cases, and not always, but most cases can and should settle. And that usually involves both parties making some concessions and walking away feeling at least a little bit unhappy that they didn't get everything that they wanted. But at least when you settle, both parties have control over the outcome, and you haven't followed a long and arduous path of litigation where at the end the prize may not have been the price that you paid to get there. So is it a win-win necessarily? Not necessarily, but I think if you can avoid a long and arduous litigation process whereby the judge or adjudicator chastises everyone for why couldn't you have just sat down and figured this out, then yeah, I call that a win.
And as Graham was saying, like, we're all going to try. There's no question. There are cases that you're not going to be able to settle because people are not reasonable. And similarly, whether it's on, whatever side you're on, similarly, you're going to have some hearings that result in a great win for the condominium corporation and the owner still doesn't accept it. And that's, I think, the first question we have here: which courts, if any, handle appeals to the CAT decisions? I actually have two appeals going to the divisional court right now. So it's the divisional court that handles it, and we have two where the CAT has given favorable decisions to the condominium corporation on issues that really should not have been there to begin with. And so you can try your best. Sometimes it doesn't work.
And in the past, I believe you kind of touched on this earlier, but the cases were brought to CAT primarily and the applicant was primarily an owner in many cases that had brought the case to CAT, but that's kind of changing now.
Yeah, sorry, Shelley, I forgot to mention that, and I hinted that I would, and so I'm glad you reminded me. We actually have two cases right now, and a third one that is brewing, where the condominium corporation is bringing the owners and tenant to the CAT on smoking issues. So before, as I'm sure those of you who've dealt with smoking know, you hope that the letters of seeking compliance, and you hope that the pleas to stop the allowing smoke transfer result in compliance, but eventually sometimes they don't. And so previously we basically had to start a court application, go through the whole court process. Now it's in the hands of the CAT. So we are starting those processes and bringing owners to the tribunal. So I'm very interested to see what the CAT is going to do with this. Now, I don't know if they'll go all the way through to a hearing, because it is entirely possible that we'll get a really strong tribunal member who will talk some sense into our smokers who don't want to mitigate their smoke transfer, and maybe we'll resolve it at mediation. That's the hope. As Graham said, that's the half win, lose, right? the mediated solution. But if we do go all the way, it'll be really interesting to see what the CAT's going to do with that. And I do think on the noise issue too, our question from earlier on, what role does the condo have? In the event that we have noise disputes between two owners, the condo does still have a role to play there to determine whether or not there's a defect, to determine whether or not there's a human rights issue, to determine whether or not someone is acting unreasonably. So yes, the CAT or the condominium corporation can absolutely be involved in a noise dispute between two owners. And so I can see in some cases the condo may want to start the CAT process, bring the two owners into that process so that it can get resolved by an independent mediator, and then if necessary go to an adjudicator, because there's only so much that a condo can do. Again, if you've got two neighbors who are fighting, there comes a point where maybe you have to turn to outside help, and that's what the CAT can do for us, hopefully.
And further to your point, Nancy, it's not even just an issue of the corporation may want to get involved in the CAT. The corporation has a duty to ensure that its governing documents are being abided by. So it's now a case of like Nancy said, we try to send letters and we try to curb issues like smoking without having to resort to the next step of adjudication or starting that process. But I mean, if it's not going to work and if the issue is persisting, you do have to take it to that next step. And now we know that next step is the CAT.
Mhm. I'm looking at the two other questions and they're exactly on point to what Graham and I are just talking about. So I'll just pop on to those. And with respect to the cat, what if it's also the city? Like, can the city get involved? I say that the city is definitely one of your enforcement options early on. So call bylaw. The more that you call bylaw and have a record of bylaw coming in, bylaw making a report, and you have that report in your back pocket if it doesn't cease, that's fantastic. So yes, start with the city, start with a letter from the corporation to the offending owner, your typical enforcement processes. And then if that doesn't work, you've got all of that evidence in your back pocket if you have to end up at the CAT. So really great for, sorry, I missed the name there. Whoever brought up the city. Yes, definitely get your bylaw officers involved early on if you can. Graham, did you want to tackle the cost issue, the CAT cost and enforceability?
Are CAT costs enforceable by law? So when we seek these CAT costs, if it is an order by an administrative tribunal, yes, it's enforceable. And in fact, Nancy, you can jump in on this too, because I don't want to put my foot in my mouth here. But what's the CAT's position right now on the idea of charging these costs back in the same way as a common expense?
Yeah, my understanding is that when you get those CAT costs, that they will constitute under Section 134 a recoverable by way of a lien. I don't know that they've had to go so far as to say that. We've been successful in our cases. It's the implication.
It's a compliance order.
Exactly. Yeah.
So that's how at least I would treat it.
Exactly, and that's how we've treated it so far, and haven't had any pushback on that. So.
Another one is, can the CAT hear disputes to remove a board member director? So that would be an example of something that's not in the CAT's jurisdiction. And if the CAT were to receive an application of that kind, it would likely be dismissed. And that's an example of something that could result in costs to the party that tried to bring that, costs against the party that tried to bring that application.
Yeah, and the next question, I'm going to try and decipher it, is the noise issue regarding floor soundproofing was not in the rules and bylaw. So that's a great example of how these cases can get ridiculously complex. So it can start off as a noise dispute between two owners, and it can quickly turn into, do our governing documents have sufficient provisions in them in order for us to deal with them? Was the owner required to put soundproofing down? Do they have hardwood flooring? What is the level of compliance? Have we tried to put carpets down? So that's a great question, because it really does show that the complexity to which these cases can get. In some cases, it is just somebody playing their music loud, or we in the past we've had people screaming and yelling at each other, all sorts of situations like that. But if it is the noise and the flooring, absolutely, it could turn on whether or not somebody has the proper governing documents in place, and whether or not, as maybe a new purchaser, they knew about it, or did they not know about it, or was the old purchase or the old owner on the hook? Is the corporation on the hook? Very complex issues.
Absolutely.
And with these complex issues, I want to echo something Nancy said earlier about it was with respect to the bylaw question and building a record. I think especially with noise, one of the biggest challenges can be to prove it. And so you always want to ask yourself, if you're going to send a formal legal letter to someone kind of saying that we know you're causing too much noise and you need to stop, you need to always consider, especially now that you may very well end up in front of a CAT adjudicator much more quickly than you would have ended up in front of a judge. Can I prove this if need be? And so one of the best things you can do before it's escalated to the CAT is make sure that you're carefully documenting and creating a record that will be able to show that we are not just creating a fight for the sake of creating a fight. We can show with objective evidence here that there is an issue and it needs to be resolved.
Absolutely. It's these issues can be very complex. I think we could wrap many of these comments up by saying that these issues can be very complex, and I think that it's not as easy as who will represent, and by consulting as a team with the directors, your board, legal counsel, you can determine where the steps you're going to take to address these cases. I think we can go on all afternoon, but we've just about reached our time limit. So I'd like to, first of all, thank Nancy and Graham very much today. Great conversation. It's definitely at the forefront, and I know a lot of people that are attending today have not experienced a CAT case or been involved in a CAT case, but I think that you will be in the near future with many of these disputes that are happening, because they will be with the expansion.
I think you're right, Shelley. Thank you so much for having me. Graham, it's always so much fun to present together. Just a delight. So thanks so much.
Yeah, thank you very much, Shelley, and to everybody who came to watch us today. We appreciate you taking the time.
Thank you. And I also wanted to just touch on our next session, which is the flashback to 2017. It seems like yesterday. The changes that came about with the Condominium Act and the amendments. So we are, that will be our next session in February. So please stay tuned. I'll stop sharing my screen for a second, and I'd like to again thank you very much, Nancy and Graham, for taking part in the discussion today. And everyone, have a good rest of your afternoon. Take care, stay well.